What do we actually mean by regulation? Well, definitions might well differ, but at its core, my own interpretation of regulation is that it's a tool that we use, a mechanism by which we assert control to deliver a desired outcome. And what is that desired outcome? It's the one that we define as society as being fair or right in those sets of circumstances. So in other words, you could argue that regulation is nothing other than codification of our values, which are then hardwired into the infrastructure of the society in which we live. But just as our values ebb and flow and evolve over time, as does regulation, so periods of great regulatory growth, as we saw post the World War II era, where there was a defined collective effort towards a goal of nationalisation and greater regulation for an outcome around greater good, those periods have been followed by deregulatory efforts. And at a macro level, one could view that constant longitudinal ebb and flow, the back and forth, as a system that's seeking to find itself in an equilibrium. But I would argue that any drive for deregulation as an end in itself is one that misses all of these complexities. Sure, regulation is costly to adhere to, I agree. It can be burdensome. It can be restrictive sometimes, and certainly there's tons of evidence to suggest it might actually be stifling to innovation. But that's if you ignore the other bit of the equation. Because it also delivers equality, safety, equitable distribution, consumer protection, ethics. So when a choice is made to deregulate, it's not simply the stripping away of a number of rules in the rule book that we're doing, but rather the reduction of those particular benefits in a trade-off for a better outcome elsewhere.
The theme that I thought came across really clearly from today was the importance of trust, and the fact that we're seeing a serious erosion of trust in many of the activities and services that we've taken for granted today.
Now, the starting point is that, for the most part, people think that competition is a good thing, and many lawyers argue that in front of competition authorities such as the Competition Appeal Tribunal, which I happen to sit on myself. And there is a view that, notwithstanding the potential benefits of competition, that there are also circumstances in which competition is not necessarily beneficial. And we associate those with the failures of market failures. And economists in particular draw a distinction between three types of goods and services. Search goods, that is to say, goods and services whose quality you can assess before you purchase, such as apples and oranges and haircuts. Experience goods, where you can't do that straight away. It takes you some time to do it. For example, in relation to consumer durables, washing machines, cars, etc. And then there are things that economists term credence goods, where even after the event, you can't actually establish whether or not you necessarily got a good or bad service. And that in particular applies to many of the services, to legal services, to medical services, to financial services. And the problem that often arises in relation to that is not so much that you don't know what you got, it's more that you don't know what you could have got or should have got. In other words, the benchmark is not always clear cut. Now, a response that is made to problems in that sphere is to think in terms of regulation or certification or standard setting, and indeed the argument behind professionalization is really to try and address that market's failure. Professionalization that comes through screening individuals, through training, and through standard setting. And that works in some areas, but it doesn't work everywhere, and in particular an illustration of where it doesn't necessarily work terribly well is in relation to financial services. But it is only a very modest way of trying to correct the problem. Because inherently, what underlies all of these problems is a matter of trust and trustworthiness. To what extent can we trust the party with whom we are engaging? And in that regard, the way in which competition operates is not necessarily beneficial, because if one can't, even after the event, evaluate the quality of service, then that encourages essentially a run to the bottom. And in thinking about the relevance of law and lawyers to the process of promoting the success of companies, one therefore has to increasingly focus on this issue about how can one promote these intangible aspects of trust and relationships between individuals. And in that regard, what is emerging as being particularly important is the role that lawyers play, not only in terms of just promoting the traditional aspects of the way law impacts business, but also the elements that have to date received less attention. So, for example, if one thinks about company law, then, while Section 172 refers to the responsibility of directors in upholding the success of the company for the benefit of members as a whole, let us say the shareholders, it also goes on to talk about the responsibility in relation to the promotion of long-term interests and the interests of other stakeholders. And that is something that, in regard to this element of trust and purpose, is of steadily increasing significance. In other words, there's a great deal that one can do within the context of existing company law to promote this idea that actually what is required to achieve the success of companies goes well beyond what is currently emphasized under company law. And indeed, what is going to probably occur over time is that we will go further in terms of actually establishing purpose as being the fundamental aspect of the way in which we design company law, with an expectation that companies incorporate and state in their articles of association what the purposes of the company is.
I believe that our legal systems are, we can have societies which can do without various philosophies and various religions and various norms and so on, but we cannot have a society without its law.
Now, in order to survive, you have to have some norms, some customs, some codes of conduct. And so, for example, when the frigate, the Medusa, hit a sandbank, I think it was on the 5th of July, 1816, a sandbank off the coast of what was then Senegal, now Mauritania. They were about 90 kilometers from the coast. There's a big sandbank. The captain had never heard of this sandbank, so he wasn't a very experienced captain. And it was in the middle of a storm, so the crew built a raft, and 147 people got on this raft, and 15 got off at the end of it after 2 or 3 weeks, floating around, helpless. And the basic reason why the people on this raft didn't survive, they didn't survive because of the fighting for the brandy and the biscuits. It wasn't a lot, because the brandy and biscuits, they had to throw a lot off because they were up to here in water. And the others were killed in the fighting. Now, the captain and the crew had got in the boats. They were going to tow, this raft to the shore. They were going to row, but then they found they couldn't do that, so they just cut the ropes and disappeared off, you see. Now, the other situation, which I like to compare that with, was the Chilean miners. I don't know if you remember, but back in August 2010, 33 Chilean miners ended up, right under, 3 kilometers of rock, which had fallen on them. And all of them got out. And so, apart from the circumstances, there was a key difference. The Chilean miners, the first thing they did when they realized, in the middle of their lunch from this law, they realized that they could be down there for a long time, so they elected a leader. And they empowered the leader to make rules. And the leader said, we have to work out how much food and water we got down here. We could be down here for a long time and maybe forever. And they agreed on a tiny little ration to share the food. I don't know how they're 5, 6 weeks or something down there, a long time. But every single one got out. Now, what was the difference? The Chilean miners had a legal system. They had a government. They had a constitutional law. Very rudimentary, you know, they weren't college-educated guys. And the ruler made rules, emergency rules. So they had a legal system. Whereas the people on the raft of the Medusa didn't have any rules at all. There was no leader, no captain. The captain left the ship. One of the most basic rules, you know, of maritime law. And they had no rules about the brandy and the biscuits. They fought for it. So and I'm saying that the rules, the laws which are now essential to our survival include corporations, money, capital markets, banking. They include central counterparties. If we didn't have a central counterparty for foreign exchange or derivatives and so on, I can tell you now, there would be nothing on the plate for breakfast. And all of those are saturated, drenched with some moral view, as Colin was pointing out, I think very, very aptly. Even if you take something like taxation, the idea that we should have a forcible kind of charity to share with the people of the same is a moral choice. That's a moral choice. Something like money, the pricing of money, the inflation of money involves a redistribution from the rich to the poor. Even the pricing of money, the forcible seizure of your money by a central bank and saying, you can get 80% for this, not 100, which is what Alan Greenspan did, is at bottom a redistribution from creditors to debtors. I know it's more complicated than that, and I'm not saying you're not allowed to do that, but that is the effect. And so you have to know that at bottom you're making a moral choice. Now, when we move to regulation, that to me raises some really basic questions of a moral nature, which are not just utilitarian, Benthamite convenience and achieving some sort of economical, mechanical results. Regulation is, especially financial regulation, involves the appointment of an arm of government, somewhat distant, but still part of government, which makes the laws, so it makes its own rules. It then executes them in the sense that it has executive power like a cabinet, and it also has judicial powers in the sense that they enforce it. And they have their own rules, their own little tribunals and so on. And all of this is, so what you there have is something which challenges some really basic constitutional ideas, which is the concentration of power. You've got the legislative, the executive, and the judicial in one body. Now, I'm not saying you mustn't have that, because we have to have that system. It's not really practicable not to have that. But it does mean that these systems have to be applied with caution, having regard to the rule of law. I'm a big rule of law addict, to be honest. Because, for instance, in a regulatory system, there are sanctions which are they're called administrative sanctions, but they are criminal in nature because they're not compensatory. So they are criminal in nature. They don't involve being sent to jail or having your head chopped off, except in some countries, So they're a sort of semi-criminal sanction. But they are completely without the protections of the criminal law at the most basic level.
My starting point would come as no surprise to those of you in the audience, who, whether you're a client or a practitioner, is that solicitors are right now operating in a ferociously competitive environment. And I can make that point good quite easily by comparing what life was like when I started in litigation some 35, 36 years ago compared with life today. So when I started, a new piece of work would involve, particularly as a litigator regularly, something urgent, referred to me from another associate or a partner, or later from a client directly, and as a litigator, I would know that the person on the end of the telephone, or believe it or not, the telex in those days, I won't say what Philip was using, but anyway, was that person, being serious about it, was in trouble and needed help. And I would work, and still work, incredibly hard, initially on my own, and increasingly as part of a team, and then team leader. And I would work evenings, weekends. If my wife were here, would say that I would regularly cancel holidays. And either I got the client out of trouble or I didn't. But the one surefire thing is they always got me and my firm at its very best, acting resolutely in their best interests. And in terms of price and cost, I would of course keep the client regularly informed on the amount of time I had on the clock. In those days, it was litigators particularly were working on the hourly rate. Most of the transactional departments were working on billing pretty much at the end. Now, and it is absolutely down to competition, I am now sent a very vague factual outline. I'm sure this will be very familiar to many of the people in this room. A very vague factual outcome, told what the client would like to achieve. I've no idea how many documents are going to be involved or how many witnesses, but I'm asked to come up with an upfront price. And that is then put into a tender process. And that happens even with the most sophisticated clients I have in the land. And that is my life. Now, so just focusing on the issue, what does that kind of competition and that kind of focus on upfront price do to my professional obligations? Well, let's not be naive. It absolutely has to put them under strain. But then let's not even dance around. Of course it does. The fact that when I'm talking with a client right at the beginning about pricing is healthy and it's good. And taking the client along the pricing journey and cost journey with you is absolutely the right thing to do. But if we ever get to the position that it's that upfront price, fixed, say, which drives everything, it would be extraordinary if I was not along the way looking for ways to absolutely meet that price. And that means that there will always be areas of judgment. Do I look for these documents? Are they really relevant? Well, it's pretty grey. Not sure. How about interviewing those witnesses? Well, it could be relevant, but I'm not certain. A lot of travel and a lot of time. There will be numerous, and there are in my life, always grey areas of judgment. And the way in which we deal with that is obviously maturely. If you're able to, and it's a huge if, go back to the client and say, well, you know what we thought, this has now happened. But I tell you what, you try to do that, it is extremely difficult. And once clients start to be treated exclusively as customers with whom I should be seeking to sell a car or transact with, rather than somebody with whom I want to build a trusted relationship. Once somebody stops in my eyes being a client, becomes a customer, I think we're in very, very dangerous waters. So if we take, there's a couple of proposals out there at the moment, which of course I'm not suggesting at all that they're other than well-intentioned, and they are. The first, the proposals by the Competition and Markets Authority that solicitors' prices effectively should go up in the window. It's much more complex than that, and of course I'm in favour of greater transparency of pricing. But you combine that with a proposal, again very much in the name of competition, that solicitors should be able to work outside a regulated firm, in an unregulated organisation, not a deregulated one, unregulated one, then I think you have a double whammy. The unregulated companies, again, let's not be naive about it, will absolutely treat the individuals concerned or companies concerned as customers, as people they want to transact with. And any of you in this room who've received the barrage of cold calls, which I still receive, will know who those people are on the end of the line. They're people who are regarding you as somebody to make money out of.
From the regulator's perspective, yes, competition and innovation in financial services can bring benefits, but be very careful about what unintended consequences may emerge from that and what measures you might put in place to mitigate those unintended consequences.
So, deregulation of financial services has its roots in the labour market reforms of the 1980s. Back then, the city was very much a closed shop labour market. Everyone knew each other largely, and business was done on a word is my bond basis. This honour system kept professional standards quite high, because if you did the dirty on someone, you'd pay for it reputationally and in terms of access to future business. Just as the city was opening up, stock exchange reforms were also happening in the name of innovation, and that saw a rapid expansion of UK capital markets, bringing more money and more jobs to the UK, which was a good thing. But technology and globalisation also enabled the creation of ever more complex financial products and increasingly anonymised trading. In this context, fiduciary responsibility, so these are the duties of loyalty and prudence that financial institutions owe to their clients and beneficiaries so that they're handling money with care and conflicts are dealt with transparently, should have become more important than ever. Instead, the industry became highly transactional, conflicts of interest were rife, and a casino mentality pervaded many parts of the sector. The systemic risks, when they did materialise, were catastrophic, as everyone knows. It brought down the likes of Lehman Brothers, which had been around since 1850, Bear Stearns around since 1923, and then in a bid to avoid the collapse of entire economies, countries came to their knees. So you can start to build up a picture of how far the UK had moved in just a few decades from relationship and trust-based financial services with strong professional ethics to a transactional business where short-term profit-making and bonuses trump much else. And of course, the roots of all of this, though well-meaning, were in the quest for greater innovation and competition, just as seems to be happening now in legal services. So what lessons might be drawn from this rather sorry story for regulators of the legal profession? I think I've got four main messages. First, be careful what you wish for. Deregulation can open up new opportunities, but also new risks. Second, a shift from relationship-based to transactional client dealings leads to a short-term focus that may well mean the client doesn't get the best quality advice. This risks lowering trust in the profession and necessitate re-regulation in due course. Third, for the client, competition and innovation brings with it complexity and a proliferation of products. Not every end user will welcome greater diversity and choice, and in fact, it can put people off. We've seen that with the opening up of the telecoms and the energy markets to competition. It brings benefits, but it also can be really exhausting trying to work out what the best energy or mobile phone deal is. And finally, this doesn't mean don't deregulate, but it does mean a careful consideration of the trade-offs and potential unintended consequences is needed.
And I want to just come back to your Chilean miner example, because I suspect that when the Chilean miners were electing their leader and deciding what they needed to do and the rules by which they should behave, they did not pick up the organisation's code of conduct as to what needs to be done. They designed it to meet the circumstances that they faced. And I think that that is actually an important lesson, and a lesson that we should be trying to learn is, where does one actually get better behaviour than the sort that both Simon and Ingrid were bringing out in their presentations? And to come back to the point about codes of ethics or codes of conduct, two of the companies that had the best specified codes of ethics of any company in the world were Enron and Volkswagen. And if you look at them, they were particularly detailed and well specified, and everyone could admire precisely what they stated. And the issue is obviously how does one actually implement and ensure that those worthy sentiments are adhered to?
But I do think that the word trust is absolutely at the heart of everything that we are talking about today, and it grows across the industries, whether you're talking about financial services, oil and gas, energy more generally, and the solicitors profession. It's all about trust. And I think what is really required going forward, and I would say this because, of course, I'm the Deputy Vice President of the Law Society, but it's just what I believe firmly is what is needed is actually a kind of enhanced public education as to why it is overwhelmingly in the interests of clients that when they're in trouble that they go to see a firm's solicitors. And I think unhappily, for all kinds of reasons, the brand of solicitor has regularly been under assault. In terms there's a phrase regularly used of unmet legal need, I have absolutely no doubt it's because quite regularly individuals consider that they can do it themselves and that a solicitor will not add value. And that's unsurprising because if you listen to what the government has had to say over a number of years, the government, for fairly obvious reasons, are not a fan of solicitors. We keep judicially reviewing them, pains in the backsides. We keep making claims on the NHS, and we have this awful thing called privilege, which stops government finding out what our terrible clients are telling us. And they make no bones about it. And the press are not great fans of solicitors because they believe that transparency is everything, because the press wants to know everything, and what they really want to know is what your clients are telling you, because that's obviously the interesting stuff.